Welcome to the Deep Dive. We are jumping into, well, a pretty systemic crisis today.
Yeah.
We're tackling this really startling argument that every single law-abiding American, right now, you, me, our listeners, might be committing multiple federal felonies every single day. And crucially, without even realizing it, this isn't some hypothetical. It's about the reality of modern American law.
It really does sound like something out of a dystopian novel, doesn't it? But yeah, this chilling idea is the core of our deep dive today. Our main source here is Harvey Silverglate's really important work, 3 Felonies a Day, How the Feds Target the Innocent. We're digging into the sheer, almost unbelievable breadth of the U.S. criminal code and how its, expansiveness basically puts every single citizen potentially in the crosshairs of federal prosecution.
Right. And our mission here, it's important to state this up front, is really a forensic examination. Mm-hmm. We're setting aside political leanings. Mm-hmm. This isn't about left versus right. It's a nonpartisan look at a systemic legal vulnerability. It's about the erosion of the rule of law itself. We need to grasp how these vague, sprawling federal statutes, often enforced really aggressively, how they fundamentally alter the relationship between citizens and the government.
Exactly. And Silverglate's warning isn't just about bad laws, it's structural. It's about the integrity of liberty itself. The danger, he argues, often isn't coming from lawmakers who are, actively malicious. It's more insidious. It's encroachment by, as the quote goes, men of zeal, well-meaning, but without understanding. These are officials, maybe prosecutors, maybe regulators who think they're doing good, but they use these elastic, really opaque laws in ways that turn the justice system into, well, a tool of arbitrary power, affecting ordinary people, professionals, you name it. If you can't know the law, how can you follow it? That puts liberty itself at risk.
Okay, let's start unpacking that vulnerability. And I think we have to begin at the absolute bedrock of Western criminal law. The idea of intent. Yeah, for centuries, hundreds of years, the foundation was crystal clear. Crime needed 2 things. You needed the physical act, the actus reus, the, evil-doing hand. Mm-hmm. But just as vital, you needed the mens rea, the evil-meaning mind. You had to intend to do wrong, or at the very least, be incredibly reckless about it. Without that guilty mind, maybe you caused harm, maybe it's a civil issue, but it wasn't supposed to be a crime punishable by, losing your freedom.
That principle, the mens rea requirement, that's the shield. It's what separates an accident or ignorance from genuine criminal guilt. And there's a fantastic case that shows the Supreme Court defending this line, Morissette v. United States back in 1952. It's quite a story. Morissette goes onto a government bombing range. He sees these old bomb casings lying around. He picks them up, takes them. He doesn't hide it. He claims he genuinely thought they were abandoned scrap metal, worthless junk.
So the act itself, taking government property, that clearly happened. The actus reus was there. But the mind, the intent.
That's the key. He had what the court later described as an innocent intention. No criminal intent to steal anything. He just thought he was salvaging stuff nobody wanted. But at his trial, the judge actually told the jury, basically, don't even consider his intent. Ignorance of the law or thinking the property was abandoned, that's no excuse. So Morissette gets convicted of theft.
But the Supreme Court stepped in.
Unanimously. Justice Robert Jackson wrote this incredibly powerful opinion overturning the conviction. Jackson hammered home that you absolutely must have that combination, the evil-meaning mind with an evil-doing hand. He stressed the court must insist on a culpable state of mind. He warned that if the government could just criminalize acts without intent, especially with this growing number of regulations, it would fundamentally undermine the whole concept of criminal justice. It was a huge statement defending that traditional line.
But as Silverglate lays out, the modern federal system seems to have, largely ignored that warning, hasn't it?
That really is the modern departure, and it's how things started to go off the rails. As the federal government grew, especially after the New Deal, you got this explosion of regulations, environment, finance, health, you name it. And Congress started writing these laws, often without explicitly putting in that mens rea requirement. The thinking, or maybe the justification was, these are just public welfare offenses. Kind of like strict liability. The idea was people shouldn't escape just because a rule was complicated or they didn't know they broke it. And that's the trap. That's how ordinary, well-meaning people suddenly become criminally liable for things they never intended.
And this drift away from intent leads us straight into the heart of Silverglate's argument. These vast, often undecipherable statutes.
Yeah.
Laws so vague, they basically become tools for arbitrary power.
Exactly. Let's look at two really stark examples of this. This constitutional corrosion. One statute that's just breathtakingly broad, and another that's almost impossibly technical and confusing.
Okay, let's start with the broad one. The infamous Honest Services Fraud Statute. That's 18 U.S.C. Section 1346.
Yeah. That's the one. And it's amazing. It's only 28 words long. But the damage it caused was immense. It let prosecutors go after public officials, private business people, anyone, for depriving others of the intangible right of honest services. What does that even mean? Well, historically, prosecutors used it for almost anything they disapproved of. Maybe some sharp business practices that weren't technically illegal but looked bad, or a politician failing to disclose some conflict of interest, even if state ethics laws didn't require it. It was a catch-all.
It sounds less like a specific crime and more like a blank check for prosecutors to investigate anyone they didn't like.
That's precisely how it functioned. And eventually the Supreme Court had to step in. In the Skilling case, related to Enron, all 9 justices, liberals, conservatives, everyone agreed that the statute, as the Justice Department was using it, was unconstitutionally vague. It completely failed to give people fair notice of what conduct was actually criminal. It didn't define honest services.
So the highest court basically said, this law, as written and applied, is fundamentally unfair. We have to fix it.
They did. The majority essentially rewrote the law from the bench. They narrowed it dramatically. They said, going forward, honest services fraud applies only to classic corruption, clear-cut bribery, and kickbacks. Things people generally understand are wrong. They saved the statute by shrinking it. But think about it. The fact that the Supreme Court found the core concept unfathomable, that shows just how far prosecutors had pushed the envelope, creating legal theories that really threatened basic fairness.
Okay, but here's where it gets, well, frankly disturbing. You see a real inconsistency in how the court applies this void for vagueness idea. Because just days before they ruled on honest services, that same court looked at a national security law that was arguably even more confusing.
You're talking about the Holder v. Humanitarian Law Project case?
Yes.
This involved a law that criminalizes providing material support to designated terrorist organizations, and the definition of material support was incredibly broad. It included things like expert advice or assistance, and even training.
And the people caught up in this weren't teaching bomb making, were they? They were human rights groups.
Exactly. These were advocates trying to teach designated groups like the PKK in Turkey or the Tamil Tigers how to use peaceful legal means to resolve conflicts, like how to petition the United Nations for help or how to engage in peace negotiations under international law. They were promoting nonviolence through legal channels. But the government argued this was illegal training and expert advice. They said it helped the organizations operate more effectively, even if the advice was about peace.
So when the advocates argued, reasonably, that this law was way too vague, how do you draw the line between permissible advocacy and illegal expert advice? What did the court say? Especially compared to how they treated the 28-word honest services statute.
It was a complete flip. Not one justice found the material support statute void for vagueness. The majority basically said, oh, a person of ordinary intelligence can figure this out. They argued that teaching specific skills, like how to file a petition, was criminal training. But just giving general information might be okay. It required this incredibly fine, almost impossible line drawing. It really defied the whole standard of fair warning for ordinary people. They upheld the law.
That difference in treatment is really chilling and suggests that when national security is waved like a flag, the fundamental constitutional need for clear laws just evaporates.
The rules absolutely change, and the implication, as Silverglate points out, is profound for civil society. It means the government can use these incredibly vague national security laws or other broad statutes to potentially target almost anyone, even prominent political figures if their advocacy crosses some invisible line.
You mentioned the risk this creates for politically active people.
Well, think about the material support law again. After the Holder decision, legal experts pointed out something alarming. This ridiculously broad statute could technically have made criminals out of major American political figures. People like former Attorney General Michael Mukasey, former NYC Mayor Rudy Giuliani, former Homeland Security Secretary Tom Ridge. Just because they spoke publicly at conferences in support of the Mujahideen Khalq, or MEK, an Iranian opposition group, at the time they spoke, the MEK was still officially listed as a foreign terrorist organization by the U.S. government. Their political advocacy, under the court's logic, could arguably have been twisted into prohibited material support.
Wow. So even high-profile figures, acting openly, engaged in political speech, could find themselves technically violating a felony statute because the language is so poorly defined.
That's the danger. If the government can't even clearly define the crime, but conviction means decades in prison, then the rule of law starts to break down. It becomes about selective enforcement. It depends entirely on who the prosecutor decides to target, not on clear violation of a known law.
Okay, so this incredible breadth in federal law means the net isn't just catching hardened criminals anymore. Increasingly, it's catching ordinary professionals. Executives, doctors, accountants, lawyers, people snagged by some obscure technicality and a regulation they might not have even known existed, let alone understood its full implications.
The scope is just staggering, and it leads to this really cynical game that Silverglate describes being played among federal prosecutors, particularly in the Southern District of New York. He calls it a darkly humorous exercise. Junior prosecutors would apparently gather, maybe over drinks, and they'd pick a completely random famous person, someone seen as virtuous like Mother Teresa, or maybe an icon like John Lennon. And the challenge was, find a plausible federal felony you could indict them for.
And they weren't looking for obvious crimes, right? They were digging into the obscure corners of the U.S. Code.
Absolutely. They weren't saying Mother Teresa was running a drug ring. No, they'd find things like violating arcane regulations, or making a technically false statement on some form, or obstructing the mails in some minor way, or using incredibly broad fraud statutes. The whole point of this morbid game was to demonstrate something crucial. The federal code is so enormous, so labyrinthine, and so full of vague prohibitions that a determined prosecutor can always find some statute, or usually several, to pin on almost anyone. It becomes the ultimate weapon of discretionary power. It's exactly what Justice Jackson feared, the law as a trap for the unwary honest citizen.
To really see the destructive power of this, though, we need to look beyond the game to a real-world corporate catastrophe, the complete destruction of Arthur Andersen. This wasn't some fly-by-night criminal outfit. It was one of the biggest, most respected accounting firms in the world, and it was annihilated by a single prosecution.
Yes, the Andersen case is just devastating. They were prosecuted and ultimately convicted by a jury for obstruction of justice. And the irony is staggering. They were convicted essentially for following their own internal policies. This was during the whole Enron meltdown, so Andersen was obviously under a microscope. But critically, they hadn't yet received a formal subpoena demanding documents. So following long-standing company policy and on advice from their lawyers, they conducted routine file cleanup, destroying non-essential drafts, duplicates, things like that.
Standard operating procedure for any large organization.
Right.
Getting rid of clutter based on established rules.
Exactly. It was compliance with their own internal pre-existing document retention and destruction policy, a routine, perfectly legal act in itself. But the federal prosecutors seized on the timing. They argued that because Andersen knew an investigation was likely, implementing their standard policy at that moment constituted criminal intent to obstruct a future official proceeding, even though no proceeding had formally begun with a subpoena. They spun routine compliance into a criminal conspiracy.
And the mere fact of that conviction, even before any appeals, was enough to kill the company.
Instantly, it was the corporate death penalty, an indictment, let alone a conviction, for a firm whose entire business relies on trust and integrity. It was fatal. 85,000 people lost their jobs. The firm vanished. And all this happened before the case even got to the Supreme Court. When it finally did, years later, the court ruled unanimously. They threw out the conviction. They said the jury instructions were fundamentally flawed because they allowed the jury to convict Andersen without finding any actual criminal intent or dishonest motive.
So the highest court eventually agreed with Andersen's defense that the conviction was wrong, but only after the firm was already dead and buried. That's the definition of justice delayed, justice denied. A Pyrrhic victory indeed.
Completely. And the impact went far beyond Andersen. It sent a shockwave through the entire corporate and professional world. The message was loud and clear. Fighting the federal government, even if you believe you are innocent, is ruinously expensive and potentially fatal. We saw the immediate effect. Other major firms, like KPMG, facing similar pressures, quickly chose a different path. They entered into deferred prosecution agreements, essentially conceding guilt, paying massive fines, and often agreeing to cooperate against their own employees to save the firm itself. Survival became the priority, not necessarily truth or due process. The Andersen precedent changed the game.
And this danger becomes even more acute when prosecutorial power bleeds into fields where professional judgment and ambiguity are just inherent parts of the job, like medicine. The cases involving pain management doctors, like the Dr. Hurwitz case mentioned in the source, are particularly alarming.
They really are. Dr. Hurwitz, a respected physician specializing in chronic pain, found himself facing charges usually reserved for street-level drug dealers, drug trafficking. And the basis for these incredibly serious charges wasn't clear evidence of selling pills out the back door. It was based on this incredibly amorphous regulatory standard. The question was whether the prescriptions he wrote were issued for a legitimate medical purpose.
Right.
Now, who defines legitimate medical purpose? Not necessarily the medical community or peer-reviewed science. In these cases, it often boils down to the subjective opinion of federal drug bureaucrats, second-guessing a doctor's treatment decisions, often years later, with the benefit of hindsight. Criminal liability ends up hinging on whether a DEA agent agrees with your professional medical judgment.
And Silverglate points out something really disturbing. The DEA actually seemed to prefer this ambiguity. They resisted efforts to clarify the standard.
It's quite incredible. Just before Dr. Hurwitz's trial, there was pressure from medical organizations for clearer guidance. The DEA actually released an FAQ document. It seemed to acknowledge that treating severe chronic pain is complex, often requiring high doses, individualized treatment, flexibility. It looked like a step towards clarity. But then, less than 2 months later, they abruptly withdrew the guidance, pulled it back.
Why on earth would they do that? Withdrawal guidance meant to help doctors navigate this minefield.
The conclusion drawn in the source is stark. Providing clear guidelines, acknowledging the complexities and the need for flexibility would have made it much harder for the DEA to win what Silverglate calls their overzealous prosecutions. Conviction rates might drop. So they deliberately changed to keep the standard vague. Ambiguity became a tactical advantage in litigation. It allowed them to continue bringing cases based on subjective interpretations rather than clear, objective rules.
That seems like a fundamental betrayal of public trust. Prioritizing convictions over clear policy and safe medical practice. What's the effect on doctors and patients?
It creates a devastating, chilling effect. Physicians become terrified. They risk losing their license, their freedom, everything, just for exercising their best medical judgment in difficult cases. This leads directly to what experts call a fear of undertreatment. Doctors become afraid to prescribe adequate pain relief, even when medically necessary. They start practicing defensive medicine, not based on the patient's needs, but on fear of prosecution. Ironically, this fear can lead to actual patient harm, even malpractice, by failing to alleviate suffering. Patients suffer because doctors are scared.
And we see a very similar dynamic, regulatory ambiguity weaponized by prosecutors playing out in the business world, too.
Yeah.
The Leichter case involving medical devices is a good example.
Yes. Edward Leichter was a regulatory affairs executive at a company making heart catheters. He faced fraud charges. The issue was about modifications made to existing FDA-approved catheters. Did these changes require a whole new, complex, expensive pre-market approval, PMA supplement from the FDA? Or were they minor enough not to? Now, FDA regulations are notoriously complex. The general understanding in the industry was that criminal charges were reserved for really blatant, intentional fraud, not good faith disputes over regulatory interpretation. Leichter believed the modifications were within bounds.
But the trial came down to the meaning of two very basic words, didn't it? Safe and effective.
Exactly. And this is where the prosecution strategy was, frankly, shocking, according to the defense. The defense reasonably argued that safe and effective in the context of medical devices have a specific technical meaning. No medical device, especially one like a heart catheter, is absolutely safe in the sense of having zero risk. Safe, in FDA terms, means the benefits outweigh the inherent risks. It's a relative term. But the prosecutors argued something entirely different. They told the jury to ignore the technical regulatory context. They said, just use the plain, ordinary meaning you'd find in a dictionary, like freedom from danger or risks.
But that's completely changing the rules after the fact. If safe means zero risk, then every heart catheter ever sold is illegal. The standard becomes impossible to meet.
Precisely. It allowed the prosecution to take complex regulatory compliance, the kind of nuanced judgment that happens every day in regulated industries, and portray it to the jury as a violation of the simple, plain meaning of a word. It essentially turned a potentially legitimate disagreement over technical regulations into a felony, based on a definition pulled from a dictionary, applied after the conduct occurred.
So you have these incredibly broad, often vague statutes on the books. But their real power, their real danger, comes from how they're used. They become leverage in the hands of federal prosecutors armed with a toolkit designed for coercion. If a prosecutor can plausibly threaten you with 3 felonies a day, as Silverglate puts it, the risk of actually fighting back in court court becomes almost unbearable, even if you believe you're innocent.
That's the absolute core of the problem, the overwhelming pressure of the plea bargain system. Federal sentencing guidelines, mandatory minimums, they can lead to truly terrifying potential sentences if you're convicted at trial. Decades, sometimes life. So the prosecutor comes to you even if the case against you is weak or based on a novel interpretation of the law, and they offer a deal. Plead guilty to just one lesser charge, maybe get a few years, versus risking 20, 30 years or more if you roll the dice with a jury. The risk-reward calculation is brutally skewed. It forces people, including factually innocent people, to give up their right to trial just to minimize risk.
This is where the concept of the Alford plea comes in, which is just mind-boggling when you think about it. Can you explain that?
The Alford plea is deeply troubling. It's named after a Supreme Court case, North Carolina v. Alford. It allows a defendant to plead guilty legally and accept the punishment, often a significant prison sentence, while simultaneously maintaining their factual innocence. They're essentially saying, I didn't do it, but the evidence the prosecutor has, combined with the risk of a much harsher sentence if I lose at trial, is so great that I'm choosing to plead guilty purely as a matter of self-preservation. Okay. It's a guilty plea entered under duress, extracted through fear, not through an admission of wrongdoing.
And this entire plea-driven system often relies heavily on testimony from so-called cooperating witnesses, people who are often facing serious charges themselves.
That's another key piece of the toolkit. Prosecutors identify lower-level players in an alleged scheme. They threaten them with the book, potentially decades in prison. Then they offer a deal. Cooperate, testify against the main target, your boss, your associate, whoever, and we'll recommend a much lighter sentence for you, maybe even no prison time. This creates an incredibly powerful incentive, not just to tell the truth, but potentially to shade the truth or even fabricate testimony to please the prosecutor and secure that deal. As Professor Alan Dershowitz famously quipped, these witnesses are incentivized not just to sing, but also to compose, to craft a story that fits the prosecution's narrative, whether it's entirely accurate or not.
So the system itself can generate unreliable testimony, potentially convicting people based on stories told by others trying to save their own skin.
And this whole process drags more and more conduct, sometimes conduct that isn't inherently criminal, into the system. It's driven by prosecutorial practices and leverage, not necessarily by clear legislative intent. This is how you get the infamous ladder climbing technique, which is especially common in political corruption or white-collar cases.
Right. Explain how ladder climbing works.
It's exactly what it sounds like. You start at the bottom rung. You target lower-level individuals' assistants, junior partners, maybe vendors or contractors. You squeeze them hard, threaten them with serious charges based on these broad statutes. You make their lives miserable. The goal is to flip them. Get them to agree to testify against the people, higher up the ladder, the executive, the elected official, the CEO. Each flipped witness becomes a weapon to pressure the next person up until you reach the main target at the top.
Silverglate uses the federal investigation of Mayor Raul Martinez of Hialeah, Florida, as a prime example.
Yes, the Martinez case went on for years. Prosecutors targeted him using the Hobbs Act, a federal extortion law originally aimed at racketeering and robbery, but often stretched to cover local political dealings. How did they build the case? They first went after real estate developers who had dealt with the city. Initially, these developers might have been seen as the victims of alleged pressure from the mayor, but the prosecutors effectively turned them into co-conspirators, threatened them, and then offered them immunity from prosecution if they agreed to testify against Mayor Martinez.
So the supposed victims become prosecution witnesses, testifying with immunity, all aimed at convicting a specific political figure.
It's a classic illustration of how these pliable laws, combined with coercive tactics like ladder climbing, make politicians, especially at the local level, incredibly vulnerable. A politically ambitious U.S. attorney can use these tools to make a name for themselves by taking down a prominent figure. And Silverglate does cite statistics suggesting this vulnerability might not always be applied evenly. Between 2001 and 2007, the Department of Justice under the Bush administration apparently investigated roughly 7 times more Democratic public officials than Republican ones. Now, that doesn't automatically prove partisan bias in every case, but it certainly raises serious questions about selective enforcement when the laws are so broad and discretion is so wide.
And despite years of trials, hung juries, convictions overturned on appeal, Mayor Martinez was eventually cleared, I believe. But the damage was done.
Absolutely. The process is the punishment. Years tied up in court, Reputation destroyed, finances ruined, political career ended. The government wins even when it loses the case, in a sense. The aggressive use of the law, the public spectacle, the sheer cost of defense that's often enough to achieve the desired result, regardless of the final verdict.
And this heavy reliance on plea bargains, on deals cut in prosecutors' offices, has another really damaging effect. It guts the role of the judiciary as a check on this power.
It really does. It leads to what Silverglate calls the death of appellate review. Think about it. If something like 97% of federal defendants plead guilty, then these really novel, sometimes questionable, expansive interpretations of statutes rarely get challenged in the appeals courts. Prosecutors can push the boundaries, establish new theories in the trial courts, maybe even get a conviction or just leverage a plea. And because defendants can't afford the risk or cost of appealing, those broad interpretations never get properly tested by higher courts. The government effectively wins by default, setting precedents without full judicial scrutiny.
And the background of many federal judges doesn't exactly help counter this trend, does it?
Well, there's a well-documented trend. A significant number of federal judges are former federal prosecutors. They often come to the bench having spent their careers using these very tools and interpreting statutes broadly. They might be more inclined to accept the government's arguments, to buy into the amorphous definitions, as Silverglate puts it. Sometimes judges seem to actively enable these coercive tactics. Take the really controversial Sonia Singleton case from the 10th Circuit.
That case dealt directly with the legality of offering deals to cooperating witnesses, right?
Yes. The defense made a powerful argument. There's a federal statute, 18 U.S.C. Section 201c2, that makes it a felony for anyone to give or promise anything of value to a witness in exchange for their testimony. The defense argued, isn't offering leniency, potentially saving someone years or decades in prison, something of immense value. Therefore, aren't prosecutors committing a felony every time they cut a deal with a cooperating witness? For a moment, this argument caused panic at the Justice Department. An initial 3-judge panel actually agreed with Singleton, potentially upending the entire system. But the full 10th Circuit Court reheard the case en banc all the judges together, and they reversed that panel decision. They essentially carved out an exception for the government. They created a double standard. Their reasoning was basically that Congress couldn't possibly have intended this anti-bribery statute to apply to prosecutors because offering leniency for testimony is such a long-standing practice.
Wait a minute. So the court set a law that explicitly forbids bribing witnesses. Just doesn't apply if the government is the one doing the bribing.
That's the practical outcome. They read an exception into the law that isn't actually written there. It effectively gave judicial blessing to the core mechanism of the plea bargaining cooperation system, allowing it to continue relying on testimony obtained through offers of value, even potentially fabricated testimony. It's like an institutional self-preservation move that, critics argue, significantly undermines the pursuit of truth.
So when you have laws this vague, when intent doesn't matter as much, and when prosecutors have these powerful coercive tools with little judicial check, the damage doesn't just stay within the courtroom, it radiates outward. It starts corroding trust in vital professional relationships. It chills activity across civil society. Even the independence of lawyers, the defense bar itself comes under threat.
Silverglate uses the case of a Connecticut lawyer named Philip Russell to really drive this home. It's a shocking example. Russell was indicted for obstruction of justice under the Sarbanes-Oxley Act, a law passed after Enron, supposedly targeting corporate fraud. What did Russell do? His client was under investigation and had child pornography on his computer hard drive. Now, possession of child pornography is illegal. It's contraband. Arguably, if Russell kept that hard drive, he could be charged with possessing contraband.
So, faced with illegal material, Russell took steps to destroy it. Seems like the ethical, maybe even legally required thing to do with contraband. And for that act, destroying illegal material, he gets indicted for obstructing justice.
Exactly. It put him, and potentially any defense lawyer in a similar situation, in an impossible bind, a real catch-22. If you keep the contraband, you risk prosecution. If you destroy the contraband, as Russell did, you risk prosecution for obstruction, destroying potential evidence. The vagueness of the obstruction law forced lawyers into choosing between their ethical duties to their client, confidentiality, loyalty, not possessing illegal materials, and protecting themselves from felony charges. As Russell's own lawyer argued, this kind of prosecution tries to turn defense attorneys into shills or handmaidens for police and government investigators. It fundamentally attacks the independence needed for lawyers to zealously defend their clients within the bounds of the law. If the bounds are unknowable, the system breaks.
And this threat, this chilling effect from vague laws, extends directly to another cornerstone of a free society, the press and advocacy groups too, especially when old broad laws like the Espionage Act get dusted off.
Absolutely. We're seeing the government increasingly willing to threaten journalists with prosecution for engaging in routine news-gathering activities. Things like soliciting information, receiving classified documents from sources, publishing sensitive information, practices that are essential to investigative journalism. The most high-profile example, obviously, is the pursuit of Julian Assange and WikiLeaks. American authorities were clearly determined to prosecute him, and they openly scoured the entire federal code trying to find something that would stick. They looked at trafficking in stolen government property, conspiracy, wire fraud, anything that could possibly apply.
And ultimately, they landed primarily on the Espionage Act of 1917, a law passed during World War I.
A very old law designed for wartime spies. And yet it's being wielded now in ways that seem far removed from its original intent. It's being used not just against leakers like Assange, but potentially against journalists who publish leaked information. And even against private citizens like lobbyists who aren't government employees and haven't taken secrecy oaths. Remember the case of Stephen Rosen and Keith Weissman, two lobbyists for AIPAC, the pro-Israel lobby group?
Right. They were charged under the Espionage Act too, not for spying, but for receiving and allegedly sharing classified national defense information they got from a government source.
Exactly. These were private citizens engaged in policy advocacy. They weren't spies passing secrets to an enemy power. Yet, the government argued, and courts initially seemed to agree, that the broad language of the Espionage Act could potentially cover their conduct. Even though the charges were eventually dropped, the prosecution itself sent a terrifying message. It suggested that the normal flow of information in Washington, D.C., what's often called the mother's milk of lobbying and policy debate, could suddenly become criminal espionage. When you prioritize national security claims over the need for legal clarity, you give the government immense power to chill speech, reporting, and advocacy.
It essentially leaves journalists, and maybe even academics or advocates, operating under a constant threat. A sword of Damocles, as Silverglate puts it. They can't be sure where the line is. They can't intelligently weigh the risks of publishing important information because the laws are so vague and potentially far-reaching.
And this brings us to the ultimate cost, the biggest danger highlighted in the source material. This isn't just about inconvenient laws or unfair prosecutions. It's about the very nature of the legal system. Silverglate makes a direct and deeply sobering comparison between this trend in the U.S. and historical tyranny.
Can you unpack that comparison for us? It sounds pretty stark.
It is stark. Silverglate draws a parallel between the American system's increasing reliance on vague laws and what he calls crime by analogy, and the legal system of the former Soviet Union. Article 16 of the old Soviet Criminal Code was infamous. It allowed the state to prosecute someone not just for violating a specific written law, but for committing any socially dangerous act that the authorities decided was similar or analogous to a written crime. This meant effectively that the state could punish almost any behavior it disliked, whether it was actually illegal or not. It created total uncertainty. A citizen could never know if their actions might retroactively be deemed criminal. That, Silverglate argues, is a sure formula for government oppression.
And we see echoes of this deliberate legal confusion in modern authoritarian states too, right?
Absolutely. Look at the case of Mikhail Khodorkovsky in Russia, the oil tycoon who dared to challenge Vladimir Putin. His prosecution and conviction involved charges so bizarrely contradictory that international observers struggled to even understand what crime he was supposed to have committed. First, he was convicted of embezzling basically all the oil his company Yukos had ever produced, stealing it. But then later, he was charged with tax evasion for failing to pay taxes on the profits from selling that very same oil he had supposedly already stolen. You can't logically do both. Either he stole it, no profits to tax, or he sold it legally and owed taxes. The charges made no sense together.
It wasn't about legal logic. It was about using the facade and the law to achieve a political goal. Crushing an opponent. The confusion was the point.
Exactly. It highlights the ultimate danger of a system where guilt becomes subjective, where laws are malleable tools serving the state's interests, not predictable rules protecting citizens. And this brings us right back to fundamental constitutional principles. Liberty just cannot survive, the argument goes, when laws are written so vaguely or piled so high that ordinary citizens cannot reasonably be expected to know what's prohibited and conform their conduct. Justice Oliver Wendell Holmes Jr. famously insisted that a law must give fair warning in language the common world will understand. When we systematically erode that principle, intentionally or not, we move away from democracy and towards tyranny. That's the ultimate warning here.
Wow. So wrapping up this deep dive into 3 felonies a day, the picture that emerges is, well, deeply troubling. Overcriminalization isn't just about too many laws or harsh sentences, although those are factors. It's really a systemic institutional problem. It stems from federal law becoming dangerously unmoored from those traditional fundamental requirements, criminal intent, clear statutes. And that underlying weakness is then massively amplified by the incentives, the culture, and the sheer power vested in prosecutors' offices.
That's right. The end result is a system where legal accountability feels less like a universal principle and more like a selective weapon. The core issue isn't that sophisticated criminals might occasionally slip through the net. That happened in any system. The real problem, the tragedy Silverglate highlights, is that far too many ordinary, decent, well-meaning people, professionals just trying to do their jobs, citizens trying to navigate complex rules, get caught in this machinery. Machinery that seems designed for maximum prosecutorial leverage, not necessarily for justice or truth. And the collateral damage is enormous. The erosion of trust between doctors and patients, lawyers and clients, companies and their employees. The very fabric of civil society gets frayed.
And this tendency for prosecutors to use aggressive interpretations of vague laws, almost as a way to drive policy or spur institutional reform, raises a really critical question, something for you, the listener, to really think about. If the federal government truly possesses the legal tools, as the saying goes, to indict a ham sandwich, then what other mechanisms should a free and fair society rely on to figure out what these vague laws actually mean? How should we test the boundaries and interpretations of complex statutes before we resort to the life-destroying sledgehammer of criminal prosecution against potentially innocent individuals?
Should there be a greater emphasis on civil enforcement first, or perhaps administrative proceedings where the meaning of a regulation can be debated and clarified before anyone faces prison time? Maybe criminal charges should only be brought after a clear standard has been established and violated knowingly, preserving that crucial line between a mistake, even a negligent one, and genuine criminal intent. That line between a civil wrong and a criminal act that seems to be the fundamental distinction that's become dangerously blurred and needs to be defended.
The crucial distinction indeed. Definitely some food for thought there.
Well, that's about all the time we have. You've been listening to The Deep Dive from Wake Up and Smell the Freedom, where ideas percolate. Thanks for joining us as we continue to explore the ideas that shape liberty and continue to shape us today. Remember, the pursuit of liberty begins with understanding, and understanding begins with asking the right questions. Until next time.
Bye-bye.